todo el mundo y bienvenido a mi canal. Yo me llamo Sirey. Soy una abogada afro-latina licenciada practicando la ley criminal, pero como todos ustedes, a mí me fascina cuando estamos hablando de casos de crímenes reales. En este video vamos a hablar del caso de Deobra Redden. Si quieren más video en español, nada más dime allá abajo. Hi everyone and welcome back to my channel. My name is Desiree. I'm a licensed and practicing Afro-Latino criminal attorney who, much like the rest of you, has a severe fascination with true crime cases. Listen, the case we're going to talk about today actually happened in my hometown. When I saw what occurred here, I was just absolutely astonished. This case happened like a year ago at this point, but my goodness, what happened here was just mind-blowing. This is a case where the defendant, I guess for lack of better terms, tried to take justice into his own hands. This is the case of Deobra Redden. On January 3rd of 2024, Deobra Redden was on bond and prepared to be sentenced by Judge Mary K. Holthaus for an unrelated battery case. We haven't used this term a lot on my channel, but I'm trying to get you guys kind of used to court terms and stuff that you would say in a courtroom. So essentially, Deobra was exercising his right of allocution when all of this happened. The right of allocution is merely a fancy term that means he was speaking directly to the court. You'll see in all of the hearings that we discuss, the court will tell the defendant in some terms, not exactly like this, but you have an opportunity to address the court should you choose. While addressing himself to the court, Deobra told Judge Mary K. Holthaus that he didn't want to return to prison and that he was really trying hard to better himself, but he knew that he was at her mercy.
I feel like I should be sent to prison for a second time.
In response, Judge Holthaus stated that Deobra had a less than stellar record, which included 3 prior felonies, 9 prior misdemeanors, and multiple DV convictions.
3 felonies, a gross, 9 misdemeanors, multiple DVs. Got a lot going on, sir.
Although the court stated that it could appreciate Deobra's statements, she felt that with his record, it was time to try something different.
I appreciate that, but I think it's time that he gets a taste of something else because I just can't with that history.
It was at that point that Deobra did the unimaginable.
In accordance with the laws of the state of Nevada, this court...
I'm a strong proponent in the fact that I believe that respect is earned and it is not just given. The reason I say that is because we've discussed numerous cases on this channel where I personally believe that police have abused their authority. I think that police officers feel like, and this is not everyone, so I'm not speaking for all of them. I feel like some police officers feel like because they have a badge, a gun, and a title, you're supposed to bow down to them. And I don't feel that way. We will mutually respect each other, and that's just how it's going to go. All that said, I feel like Judge Holthaus here has earned her respect, not only by virtue of being on the bench, not only by virtue of her age, which does come into play in some of the charges we'll talk about later, but just by virtue of how I felt she represented herself in the courtroom that day. I have been before some of the rudest judges you can ever think of. Literally think Judge Judy, but in a criminal context. Despite that, and despite the fact that I have seen numerous defendants mouth off at the court, I have seen defendants tell federal judges, and I'm quoting, to S their penises. I have seen defendants tell judges who might not have been in a federal context that they were little B words. I've seen it all. I've seen it all. But I have not seen anything like this. You should not physically assault a judge unless there was something absolutely egregious. And by egregious, I mean Judge Holthaus attacking Deobra first, or something to that effect, just absolutely unimaginable. I cannot find a singular reason where Deobra's conduct was justified. Right before Deobra jumped on the judge, she mentioned his criminal history. Specifically, she mentioned the fact that he had 3 prior felony convictions, 9 misdemeanor convictions, and multiple DV convictions. This is something that gets confused a lot of times, and I'm just going to explain this. I'm sure the judge knows this, and she's just saying it the way she's saying it to make a clear record. But domestic violence, or DV, is not a charge. I'm going to say it again in case you didn't hear me. Domestic violence, or DV, is not a charge. It is a classification of a charge. So, for example, if someone says to you that they were charged with domestic violence, that's just factually inaccurate. They were charged with some sort of other crime with a domestic violence factual basis. Does that make sense? So, for example, there's domestic violence battery, there's domestic violence assault, there's domestic violence injury to property, there's domestic violence stalking, there's domestic violence sexual assault, but all of these have to be acts of domestic violence. And we'll get into them more, but I just wanted to explain that for you. Because, and as the court already mentioned, Deobra does have some criminal history that does include a domestic violence factual basis. I thought it'd be important to review Nevada's domestic violence statute so we can see what exactly qualifies as domestic violence. Nevada Revised Statute 33.018 classifies acts which constitute domestic violence under Nevada law. 1. Domestic violence occurs when a person commits one of the following acts against or upon the person's spouse or former spouse, any other person to whom the person is related by blood or marriage, any other person with whom the person has had or is having a dating relationship, any other person with whom the person has had a child in common, the minor child of any of those persons, the person's minor child, or any other person who has been appointed the custodian or legal guardian for the person's minor child. The acts include A. Battery, B. Assault, C. Coercion, D. Sexual assault, E. A knowing, purposeful, or reckless course of conduct intended to harass the other person. Such conduct may include, but is not limited to: 1. Stalking, 2. Arson, 3. Trespassing, 4. Larceny, 5. Destruction of property, 6. Carrying a concealed weapon without a permit, 7. Injuring or killing an animal, 8. Burglary, or 9. An invasion of the home. Some additional acts that are considered acts of domestic violence are F. False imprisonment, and G. Pandering. 2. The provisions of this section do not apply to A. Siblings, except those siblings who are in a custodial or guardianship relationship with each other, or B. Cousins, except those cousins who are in a custodial or guardianship relationship with each other. 3. As used in this section, dating relationship means frequent, intimate associations, primarily characterized by the expectation of affectional or sexual involvement. The term does not include a casual relationship or an ordinary association between persons in a business or social context. So basically, and in essence, the most common form of domestic violence that we will see in a criminal context are of those people who are in a romantic relationship. So husband, wife, wife, or dating. There were specific caveats or different types of relationships that were included in Nevada DV statute, but they aren't applicable here. I'm thinking specifically of abusing that person's child. So the defendant abusing that person's own child. And that's just not applicable here. But with all of that out of the way, let's go ahead and take a deeper dive into Deobra Redden's prior Nevada criminal history. In 2011, and in criminal case number 11F17595X, Deobra was charged with battery with a deadly weapon as an act of domestic violence under Nevada Revised Statute 200 .481, which is classified as a felony. And he was also charged with injury to property of another over $25 but under $250 under Nevada Revised Statute 206.310, which is classified as a misdemeanor. As part of a plea agreement with the prosecution in that case, Deobra pled guilty to the misdemeanor charge of injury to property, and the felony charge of battery was later dismissed. As far as his sentence, Deobra received 6 months of jail, suspended upon the condition of successful completion of community service, domestic violence counseling, and the condition that he receive no new offenses. In 2016, and in criminal case number 16F01740X, Deobra was charged with battery as an act of domestic violence with 3 or more priors under Nevada Revised Statute 200.485 1C, which is classified as a felony. So in review of that statute, and specifically, let's just talk about the name of the statute. What does that really tell us? It tells us that Deobra has 3 or more prior domestic violence convictions. Now, we only heard about 1, and he didn't even plead to the domestic violence charge in that case. So how could that be? What I said to you guys specifically was that we're going to be talking about Deobra's Nevada criminal history. So that tells me 2 things. Either 1, he has other history between 2011 and 2016 that just wasn't available for me to review and discuss with you guys. Or 2, this history that comprises the 3 or more priors are from a different state. Ultimately, this case was dismissed, so much of what I'm saying is just background knowledge for your awareness, but I wanted to talk about it nonetheless. Again in 2016, and in criminal case number 16F02057X, Deobra was charged with battery on a protected person under Nevada Revised Statute 200.481.2D, which is classified as a misdemeanor. In reviewing that case, I believe there was a disposition, and the reason I believe that is because there was nothing in the court minutes that indicated that the case was dismissed or otherwise didn't proceed forward, but it didn't exactly tell me what the disposition was, so that we can't discuss. But again, I'm letting you guys know so you're just fully aware. In 2018, and in criminal case number 18F0309X, Deobra was charged with battery as an act of domestic violence with 3 or more priors under Nevada Revised Statute 200.485 1C, which is classified as a felony. Side note, but I do want you to remember that this is the exact same charge that we discussed in one of Deobra's previous cases that was ultimately dismissed. He was further charged with injuring or tampering with a vehicle with damage between $250 to $5,000 under Nevada Revised Statute 205.274, which is classified as a misdemeanor. He was charged as well with battery as an act of domestic violence, a first offense, under Nevada Revised Statute 200.485.1A, which is a misdemeanor as well. Just to explain this to you guys, it's not really uncommon for the prosecution to charge something in different ways. So we see that he was charged with the felony of battery as an act of domestic violence with 3 or more priors, but the prosecution also charged him with the misdemeanor of the same, stating that it was a first-time offense. If there are multiple theories upon which the prosecution can proceed, in most instances, they will go forward with all of their options. It's not unethical. It's not inappropriate. It might be somewhat unfair to the defendant, but the prosecution has the discretion to charge however they see fit. Ultimately, as far as this case is concerned, Deobra entered a Nolo Contendere plea to the misdemeanor charge of battery, and he was sentenced to time served. We haven't talked about this specific term on this channel, but we have talked about the term in general. So Nolo Contendere, or no contest, they're interchangeable terms. And we've talked about no contest pleas numerous times. As I've previously stated to you, a Nolo Contendere plea or a no contest plea is essentially a defendant saying, listen, I'm not going to say the word guilty I'm not going to admit to you, judge and court and prosecution, that I am guilty. But I will say that there is enough evidence that should you put this case before a jury of my peers, they may convict me. So I plead no contest to this. It's in essence the same thing. Also, with regard to Deobra's plea, I will say that it is not uncommon for the prosecution to allow a defendant to plead guilty to the lesser charge for a few reasons. One, it gets a plea accomplished. And despite what the world might think, I do think that the prosecution has a vested interest in trying to resolve cases ethically and responsibly when possible. And two, it gives the defendant an incentive to plead. Because now instead of pleading guilty to a felony, you're pleading guilty to a misdemeanor for the exact same offense. Now, your time is lessened because obviously the felony statute provides for more time as opposed to the misdemeanor. So all of this just incentivizes all parties. In 2021, and under criminal case number 21 CR 015292, Deobra was charged with 4 counts of battery, which constitute acts of domestic violence, with 3 or more priors under Nevada Revised Statute 200.485.1c, which are felonies. 1 count of coercion with force or threat of force under Nevada Revised Statute 207.190.2a, which is also a felony. 3 counts of battery by a prisoner, probationer, or parolee under Nevada Revised Statute 200.481.2f, which are also considered felonies. So what is it that we know about Deobra's status after reading these charges right here? Well, he was charged with battery by a prisoner, a probationer, or a parolee. So we know that one of the other cases that we couldn't find the disposition to, he was either sent to prison, he had completed a prison sentence and was on parole, or he was placed on probation. Much like those cases I just discussed, I couldn't find the resolution here either. But it did resolve because nothing in the minutes indicated to me that the case was dismissed. In 2022, and under criminal case number 22 CR 042648, Deobra was charged with attempted home invasion under Nevada Revised Statute 205.067.2, which is considered a felony. And he was also charged with destruction to the property of another with damage ranging from $250 to $5,000 under Nevada Revised Statute 206.310, which is classified as a misdemeanor. This is another case that I couldn't find the disposition to, but again, I believe there was a resolution because nothing in the minutes indicated to me that this case was otherwise dismissed. In 2023, Deobra was charged with assault with a deadly weapon under Nevada Revised Statute 200.471.2b, which is classified as a felony. What I found fascinating when reading through the minutes for this case is that at some point throughout it, competency was raised, but Deobra was ultimately found competent to proceed, and this case did resolve. In 2024, and as a result of Deobra jumping on the judge in the case that we're discussing now, and in criminal case number 24, PC 000657, Deobra was preliminarily charged with 1 count of battery on a protected person resulting in substantial bodily harm under Nevada Revised Statute 200.481.2c, which is classified as a felony. 2 counts of battery on a protected person under Nevada Revised Statute 200.481.2d, which is classified as a misdemeanor, and 1 count of battery under Nevada Revised Statute 200.481.2a, which is a misdemeanor. The reason I say that in this case he was preliminarily charged is because the prosecution ultimately dismissed these charges and later refiled it into the next case that we're going to be discussing. Again, in 2024, and after dismissal of the prior case that we just discussed, and in case number 24, CR 00734, Deobra was charged with 1 count of attempted murder with the victim who is an older person under 200.010, which is classified as a felony. 1 count of battery on a protected person resulting in substantial bodily harm, and the victim is also classified as an older person under Nevada Revised Statute 200.481.2C2, which is classified as a felony. 1 count of extortion under Nevada Revised Statute 205.320, which is classified as a felony. 1 count of intimidation to a public official and others under Nevada Revised Statute 199.300.3A, which is classified as a felony. 7 counts of battery on a protected person under Nevada Revised Statute 200.481.2D, which are considered misdemeanors. 1 count of disregarding the safety of a person or property under Nevada Revised Statute 202.595, which is considered a felony. 1 count of battery by prisoner, probationer, or parolee under Nevada Revised Statute 200.481.2F, which is considered a felony. 1 count of unlawful acts regarding excrements and fluid by a prisoner in confinement under Nevada Revised Statute 212.189.3, which is considered a felony. And finally, 1 count of coercion with force or threat of force under Nevada Revised Statute 207.190.2A, which is considered a felony. As you can see, as part of the minutes for the last criminal record that we discussed, 2 of the charges were listed as denials by the prosecution, and all the rest are listed as dismissed to grand jury. Let me explain why. On 2 of the charges, the prosecution just outright denied accepting those charges. So that's why it's called denial by prosecution. But on all the other charges, they were dismissed to be sent to a grand jury. We've talked about grand juries on this channel, but let me just refresh you guys. Grand juries are mechanisms used by the prosecution to make a determination as to probable cause for different charges. The reason and the difference between filing it via complaint, as the prosecution did here, and then ultimately submitting it to the grand jury for a probable cause determination, is that if the defendant were preliminary hearing eligible as to any of these charges and they were filed by complaint, he would be entitled to a preliminary hearing. A preliminary hearing is literally the shortest of any hearing that I've ever been a part of in my entire criminal attorney. It's really short. It's just a hearing to determine whether or not probable cause exists. But anyways, all that to say, it's my opinion, because I don't know this for a fact, that the reason that they dismissed the charges in the final case and resubmitted it to a grand jury is to avoid a whole probable cause preliminary hearing determination issue. Now that we have all of that out of the way, Deobra entered a plea of not guilty as to the charges relating to him jumping on Judge Holthaus, and the case was ultimately set for trial. The first day of trial proceeded, with both sides giving their opening statements on September 4th of 2024. But in a strange turn of events, and on the second day of trial, on September 5th of 2024, Deobra had a change of heart, and he pled guilty but mentally ill to all charges in the indictment. Keep in mind that the records that we reviewed together are not the indictment. So what happened to the underlying battery charge that Deobra was going to be sentenced for before he attacked the judge on January 3rd of 2024? Well, obviously, he was remanded into custody and his sentencing was reset for Monday, January 8th of 2024. It was interesting because it was reset before the exact same judge, and the judge made her remarks that regardless of Deobra's attack, it didn't impact the sentence that she was going to give him. And so she sentenced him accordingly.
Mr. Almate's here now.
Morning, Judge.
Good morning. All right, this is on for the continuation of Mr. Redden's sentencing. When we were last here, arguments were concluded and the court had begun to pronounce sentence when an incident occurred. An incident initiated by Mr. Redden, preventing the court from completing sentencing. That is the sole purpose for today's hearing. Any other issues that may arise from the events that occurred last Wednesday will be handled at a future date by a different court. For purposes of the record, I want to make it clear that I am not changing or modifying the sentence I was in the process of imposing last week before I was interrupted by defendant's actions. I am making my calendar page from that day an exhibit for the court. As it existed the moment I walked in, from prior to anything happening, nothing's been changed, indicating the sentence I intended to impose. I'll let you with that for a moment. All right, that being said, in accordance with the laws of the state of Nevada, this court does now sentence you in addition to the $25 administrative assessment fee, $150 DNA fee, the $3 DNA administrative assessment fee, and $250 agent defense fee, 19 to 48 months in the Nevada Department of Corrections. How much benefit time served does he have?
It's 0 days. He was on probation when he committed the offense and was revoked on probation to serve the jail time October 25th. That time it expired at about the time of the plea. So
0 days credit.
As you can see, Deobra's appearance at this hearing was rather drastically different. So instead of being on bond, obviously he's in custody. Instead of being in not jail clothes, he's in jail garb. And additionally, he's shackled. He's completely shackled with a spit guard. And I think he had on a shock belt, kind of something that we discussed, or kind of similar to what we discussed in Lori Vallow-Daybell's case. He was also heavily guarded. There were a lot of guards surrounding him to ensure that this couldn't happen again. But as you heard, the court sentenced him to anywhere between 19 and 48 months in custody. That's 1 year and 7 months to 4 years. So that's what he was sentenced for, that underlying battery charge. The facts of that battery charge, I really couldn't find all and completely, but in essence, from what I've gathered, he attacked someone with a baseball bat. After the court imposed its sentence, Deobra's sister and his foster mother spoke out in his defense.
My name is LaDonna Daniels, Ladonna, and Daniels, Daniels.
In your relationship.
I'm his sister.
So can you just tell us, we've only seen the video, so tell us about he's your half brother, right?
No, he's my whole
He's your full
brother.
brother. So tell us about your brother and the brother that we haven't seen. Who is he like? What is he like? And how did he get in this situation?
Well, he's basically born with mental illness. He was born with crack cocaine in his system. So his chance in life was taken at birth. Deep inside, he's a good person. He's just not had the opportunity in life to be surrounded by positive people, meaning his own family. I can see that my brother just felt betrayed at the time when he was pleading and saying that he was in a better place, which is different for us all to be in a better place. I mean, when we struggle from mental illness, it's a chemical imbalance. Just as most addicts have chemical imbalances out there, who wants to stop using, who can't. It's something that we suffer from. I don't think sending him to prison is going to deter anybody who suffers from a mental illness. They need to be surrounded by healthcare professionals who can treat him, and so that he gets the right treatment that he needs.
He's been in and out of mental health court, so now he's going to go to prison on this thing. Right? You were saying to me when we were walking down here, you don't think that that's going to help him in any way.
It's not, because the people in prison are trained to, for prisoners. They're not trained for people who suffers from mental illnesses. So he will not get the proper treatment that he needs.
This case went internationally viral. How has your family been dealing with that?
Well, we've all just been thinking more, of our rights as individuals. And anybody whose mind is not of a normal person should not be judged in a manner of a person who's normal like you and myself. He tried to speak for himself, which I just think he shouldn't have never been allowed to take the stand or speak on his own behalf because of his condition.
What was your thought when you saw this video that went viral? I know obviously you're talking about your brother.
Yes, I just think his reactions were not premeditated. It was triggered because he seemed to have been pleading for his freedom. He has been off his psych meds since he got out of jail, but because he doesn't have an appointment until March of this year, so he has not taken anything at all. And I think when the judge says, you know, it's time for you to get a taste of, became a trigger, and in his mind, he felt threatened. We all have the capabilities to do what Deobra did, and that is to leap that high when our fight or flight mechanism response is triggered when we're threatened. We can jump that high. We can leap that high. So in his mind, it's realistic that his life was feeling threatened, and that's what happened.
I think this didn't say that last line and this would be a different story.
I strongly believe that. I strongly believe that because it was that statement that was the trigger.
Have you had any communication with him since Wednesday?
No, I haven't.
I have. And actually, once we found out that he didn't appear in court on that day, my mind automatically went to, what did you do to him? Where is he at? When I came, media everywhere, and I go over to the jail, and I'm trying to do the visits, and there's no visitation for him at this moment. Then why? Where is he? He hasn't called, but apparently, Tony Abatangelo, a good attorney that I know, was able to access someone from the inside to actually call, and they called me last night. And I explained to Deobra, like, it's not a circus. What you did, you know, no way do we condone it, but I know your struggles and I know the voices that you hear. And I just felt I tried to soothe them and, you know, say, just come to court and, you know, whatever's handed down, just take it. Like, what else can you really truly do? But I just felt like to even be going back in front of her courtroom, that was totally biased. Like, why? What, you know, you want to send a message or what? At the same time, he's like she said, he suffers from mental illness. It's always been documented. It's always been stated. Even when I got him from the foster care system at the age of 12, it was documented that he was severely emotionally disturbed. By the time he was 18, he left and branched out on his own. But every day, like you say, he's trying to do better. He just got released November of 2023. What, 6 weeks ago? Something like that. He just got an apartment, did everything right. Was in contact with parole and probation. He was released to them in their custody. So now you said you're finna send him back? But since in his mind, he didn't think he was going back. He was ready to go to work the following day. As we sat in the courtroom, he got a dispatch from the Teamsters. You know, he was just in a better place. And like you said, you know, I just feel it's true.
I say it a million times, and I'm going to sound like a broken record to most of you at some point if you religiously watch me. But I stand by the fact that it is hard to get a loved one, to betray a loved one, no matter what they've done. Love that you have for a family member doesn't just dissipate because of something that they've done. So their reactions were kind of natural. I felt like they're not abnormal. They weren't alarming to me. It's just, honestly, typical. As to the charges that Deobra pled to for attacking the judge, he was set for sentencing on December 10th of 2024. This sentencing was set before a different judge. That's not uncommon, specifically because the judge in that case was the victim here. So she can't really sentence him on what he did to her because that would present a conflict. So this was sent to a different judge in a different courtroom, and that's where Deobra was ultimately sentenced. Prior to being sentenced, he exercised his right of allocution once more, and he made his statement to the court.
Miss Judge Susan H. Johnson, I don't understand why the state is like really going after my character. I mean, I've always had problems since I was a little kid of like psychosis and being in big crowds and always feel like my life is in danger. I didn't know, being a young person, even in middle school, elementary school, knowing that like I fear for my safety. I'm just being me, going to school, growing up, trying to do the right things. I never get tired of trying to do the right things. The state just said that I have no remorse. Like, I feel like Judge Johnson, she doesn't know me. I understand she's doing her job. I'm not mad at her for that, but I know that I'm not a bad person. And I'm thinking, like, even she knows that, but I'm sitting here like she's doing her job, you know? And I believe that you all know that I'm not a bad person. I'm not an evil person. When I came to court on January 3rd, 2024, I was listening to music. I was in a good mood. I had a steady place to stay. I was trying to get a job. I did not catch any new charges. I'm not a bad person. I don't understand why the state is trying to prove me as a bad person. I understand they have a job to do, but this is just, it's not right to me, you know? I'm not an evil guy, and I just keep going after me. I see spirits, I hear voices. I've been going through this for over a decade now, really since 2012, you know? And I just feel attacked or just not safe since I was a little kid. And me growing up, I didn't know that I had these problems. In 2022, I came to prison for the first time. I accepted responsibility for my actions. When I did what I did, I committed a crime in 2020 of December. It was 4 years ago. I paid my debt to society. I got out thinking I'm going to get work. I was really sick and ill. I was very malnourished. I don't complain about things. I don't point the blame when people have done wrong. I still treat everybody right. And the state just stated that I have no remorse and they feel like I'm a bad person. I just don't understand why are they coming after me like this. But I understand they have a job to do. When I came to court, I know for a fact to Judge Johnson, I met Judge Holthaus in 2023 of October, and you know what she told me when she revoked my probation? She said, "Mr. Redden, I hope you get the help you truly need." I said, "Thank you so much," and I meant it. I know for a fact I'm not an evil person. I think all of you guys know that, you know? But I'm not gonna use stuff like me being on camera for my actions, you know? But I know for a fact that I cared about Judge Mary Kay Holthaus' well-being. When I left my house that day at 8 Road Circle, I left my keys to my apartment, to my family, you know? And I got in the car and I came to court doing the right thing. I gave up everything, like, in case I don't get probation. I was like, well, at least I know I tried. And I'm sitting here talking to Judge Holthaus, Miss Johnson, and I swear I started hearing voices in 2012, really in 2014. I'm gonna make a long story short, but I just want to get the facts out because I don't want the state. I understand they have a job to do, but I'm not a bad person. I'm not an evil guy. But I came to court and I'm in a good mood. I'm listening to music on my phone. I'm like, oh, whatever. And I remember I got about to hug my mom, my foster mother, who raised me since I was 11 years old. I hugged her so just in case I don't depress. You can see it in the videotape. So I was in a good mood. I don't want to be known as a person who has mental illness because those people get attacked. I've heard so many people who have mental illness commit suicide and kill themselves and commit things that they really don't mean. I hope I don't have mental illness. I try not to have mental illness, you know. I don't want to be known as a person who has mental illness because they get attacked, you know. So I try my best when I'm going through all these problems. Since I was a little boy, like I told you, I didn't know I had these problems until 2 years ago. I was sitting down in prison and I had this dictionary and I was like, oh, that's what that word means. That's what that really means. I didn't know that. Oh, stuff has a deeper meaning. You know, like, wow, I never think like this. I was in prison with nothing to do. I did a 12 to 30 months. I did 15 months total, and I cleaned up my sentence. I paid my debt to society, and I got out as a good, productive member of society. I didn't know and didn't want to believe that I had mental problems. You know, I started seeing spirits. November 2022. I'm not making excuses for my actions, but I'm saying I'm not a bad person. And I know that I did not intend to kill Mary Kay Holthaus. I know I cared about her well-being, Judge Johnson. You know, and I came to court that day and I was talking to her and I told her I never stopped trying to do the right things. I wasn't pointing like, oh, this person did this to me. I deserve a chance of probation. Like, is this not fair? All I see was red, and all I heard her say, oh, this, like she said, and I finally watched the whole video. I was standing here in the courtroom with all of you guys, and I finally saw the entire video. Judge Johnson, I can't believe this. And I wasn't even mad at Michael also. I was like, I commend him on doing for what he did, and everybody in the prison trying to make me hate him and hate the judge, and I'm still trying to do the right thing. They putting stuff in my ear and I can't get away from it. But basically what I'm trying to say is everything I've been doing, this is just like, this is not right to me. But like I said, I know the state has a job to do. And basically what I'm saying is, I know I cared about Mary Kay Holthaus, to make a long story short, but when I was sitting there talking to her, I swear this has been happening to me since 2012. I saw nothing but red, and I heard her say, I think it's time for a taste of something else. I saw nothing but red, and I don't remember doing anything except for jumping on top of her and doing this to her robe. I was like, why are you doing this to me? That's what I wanted to ask her, if I think I knew myself, but I'm not really sure. That's the only thing I could come up with. I had 11 months, but I can't really come up with anything. But I know that I cared about Judge Mary Kay Holthaus' well-being. You know? That's all. Thank you.
After making his statement, the court sentenced Deobra to anywhere between 26 and 65 years in custody. I couldn't find an exact date of birth on this man, but I know that as of 2025, so this year, Deobra's 32. So in essence, even if he serves the low end of that sentence and those 26 years, he's literally going to serve almost as much time as he's been alive. This case was a doozy. Let me know your thoughts down below. Let me know what you think of Deobra attacking the judge. Let me know what you think of Deobra's prior criminal history. Let me know what you think of the sentence that was imposed for his attack on the judge. Do you think it was too harsh? Do you think it wasn't harsh enough? Just let me know all your thoughts down below. As always, thank you guys so much for watching. Please be sure to like, comment, share, and subscribe. Until next time, y'all take care.